Welcome back to OpenLine, talking about elder law. We have with us elder law attorney Barbara McGinnis, and I said we'd talk about wills when we came back. Fascinating topic. I mean, there's so many fights that are generated by this, and then so many people just die without wills. And so let's say I just want to give it all to my spouse. Why go out and get a will? It's going to go to her legally anyway, right? So why do I need it?
Well, there's lots of reasons why you may need it, okay? And one of the first things you need to think about is, do you and your wife own, or your spouse, do you own everything together anyway, right? So then your asset will pass several different ways. One is by will, but one is by joint ownership. So if you own the house together and all the bank accounts are together, well, he or she, who's ever surviving, is going to own it anyway. But you might still have a will, and we were talking off air about a couple of particular reasons. Maybe a common disaster where you and your spouse were killed at the same time, like a car wreck or a plane wreck. Happens pretty infrequently, but it does happen. Or spouses that die close enough together that by law they're considered to have died at the same time. Because sometimes in your document you can say that your spouse would have to survive you by 30 days or 60 days. So to name successor beneficiaries, who's going to receive when your spouse dies, or in a common disaster. If you have minor children, your will can name who your guardian's going to be for your children. That's really one of the primary reasons to have a will over a trust, would be to name those beneficiaries guardian. Right. Some other reasons that you would have, maybe your spouse, your surviving spouse, might be in a situation where they don't need to inherit the money outright, but they need to receive the money in trust themselves. And that could be because your spouse may be the sick spouse that needs care and protection, and you could have a testamentary trust that would care for your spouse as opposed to just inheriting outright. So lots of reasons.
So there are lots of reasons. Now, the other thing that I hear is there's a will. Now we have about a minute. There's a will, but the purpose of the will is to keep maybe one child or one ex-spouse or one spouse, I don't know, somebody from not inheriting money.
Right.
And how difficult are those?
They just have to be drafted well. A will is always subject to probate and is subject to being challenged, so drafting becomes extremely important if you're doing something that could be contentious. You cannot by law disinherit your spouse in Tennessee because they're entitled to at least a marital share. So a lot of people do try to disinherit spouses, and the way to circumvent that would be through the use of a testamentary trust. But you can disinherit your children, and you don't have to leave them $1. You don't have to say why you're disinheriting. You have to document in your will that you know who your children are, and just simply state that somebody's not getting their share. They're not getting anything, or they're getting a reduced share, and you leave it at that, basically. For that, you would either need a testamentary document of some sort, a will or a trust.
All right, we have to take a break. We'll come back, wrap everything up. Be back right after this.